Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Be ready for the high speed passage for JW exam. Ready? Start. Mr. Raj Malhotra, learned senior counsel, appearing on behalf of the appellant, would submit that the division bench of the High Court committed a serious error in passing the impugned judgment insofar as it failed to take into consideration the importance of holding a physical test before preparation of the select list stop. The learned counsel urged that arbitrariness on the part of the selection committee is apparent from the fact that the order of holding tests was pushed to the background stop. It was furthermore submitted that the division bench of the High Court did not assign sufficient and cogent reasons for interfering with the well considered judgment of the learned single judge and proceeded to modify the same without any application of mind stop. Our attention was moreover drawn to the fact that the purported reasons for modification, which were enumerated in paragraph 12 of the impugned judgment, really contain the statement of facts, and thus the same is wholly unsustainable. Stop stanza. Mr. P. K. Goswami, learned senior counsel, appearing on behalf of the private respondents, on the other hand, would contend that the appellant, in the facts and circumstances of this case, must be held to be stopped and precluded from raising any contention with regard to the validity or otherwise of the procedure for selection adopted by the selection committee, as he had participated in the selection process without any demur whatsoever. Stop. It is stated that pursuant thereto and in furtherance thereof only the said respondent had been appointed and had been working since then. Stop. Stanza. Our attention was furthermore drawn to the fact that against the order of the learned single judge a writ appeal had been filed by him which is pending. Stop. Indisputably, in the advertisement, the candidates were required not only to qualify in the written test but also the physical ability test. Stop. A plain reading of the advertisement clearly goes to show that the interview was to be conducted only after holding of the said two tests. Stop. In tune with the said requirements, only the candidates were asked to appear in the written test on 26/4/1998 and in the physical test on 28/4/1998. Stop. There cannot, however, be any doubt whatsoever that a selection committee in a given situation may lay down a procedure for the purpose of shortlisting the candidates, but that does not mean that for the said purpose the order of holding a requisite test would be changed. Stop. In terms of a decision which was taken on 7/4/1999, the selection committee thought to take interview prior to holding of the physical ability test. Stop. Physical ability test, keeping in view the nature of the job required to be performed by the candidates, was an extremely important one. Stop. Passing in the physical ability test is a sine qua non for selection of the candidates in the post of sub-inspector of police. Stop. It was indeed a competitive test, and the merit list should have been prepared not only on the basis of the written test and interview but also the physical ability test. Stop stanza. The petitioner filed a suit for specific performance of an alleged agreement of sale dated 15/7/2003. Stop. The trial court dismissed the suit by judgment and decree dated 19/5/2008. Stop. The High Court dismissed the petitioner's appeal. Stop. Both the courts held that the petitioner had not approached the court with clean hands and that he had failed to prove any concluded contract for sale. Stop. High Court found that the defendants in the suit were also not above board in their conduct. Stop. It found that both sides were guilty of having lied on oath and deserved to be prosecuted. Stop. On the ground that courts were overburdened with litigation, the High Court decided that instead of directing prosecution, heavy costs should be levied on both petitioner and respondents to be paid to the state, which spends money on providing the judicial infrastructure. Stop. It then proceeded to impose exemplary costs of rupees 1 lakh on the petitioner and rupees 1 lakh on the respondents and directed that the costs should be deposited with the Delhi High Court Legal Services Committee. Stop stanza. Feeling aggrieved by the dismissal of his appeal, the petitioner is before this court. Stop. On merits, we find that the concurrent findings of the trial court and the High Court do not warrant interference, and therefore this is not a fit case for grant of leave. Stop. The learned counsel for the petitioner submitted that levying costs of rupees 1 lakh against the petitioner was not warranted. Stop. He submitted that as the appeal before the High Court arose out of a civil suit, costs were governed by sections 35 and 35A of the Code of Civil Procedure and cannot exceed what is leviable under those provisions. Stop stanza. Under Section 35 of the Code, award of costs is discretionary but subject to the conditions and limitations as may be prescribed and the provisions of any law for the time being in force. Stop. Under Section 35A, compensatory costs for vexatious claims and defences may not exceed to rupees 3,000. Stop. Further, the primary object of levying costs under Sections 35 and 35A of the Code is to recompense a litigant for the expense incurred by him in litigation to vindicate or defend his right. Stop. It is therefore payable by a losing litigant to his successful opponent. Stop. When an appellant or a plaintiff has already paid the prescribed court fee in regard to the appeal or suit to the state at the time of institution, it is debatable whether any cost can be awarded to the state by way of penalty in a litigation between two private parties. Stop stanza. One view has been that the provisions of sections 35 and 35A of the Code do not in any way affect the wide discretion vested in by High Court in exercise of its inherent power to award costs in the interests of justice in appropriate civil cases. Stop. The more sound view, however, is that though award of costs is within the discretion of the court, it is subject to such conditions and limitations as may be prescribed and subject to the provisions of any law for the time being in force. Stop stanza. The Honorable Supreme Court considered the issue at length and held that ordinarily it is considered desirable not to restrict the delinquent's right to be represented by counsel or an agent of his choice, but it is different thing to say that such a right is an element of the principles of natural justice and denial thereof would invalidate the inquiry. Stop. The right to be represented by counsel or agent can be restricted, controlled, or regulated by statutes, rules, regulations, or standing orders. Stop. A delinquent has no right to be represented through counsel or agent unless the law specifically confers such a right upon him. Stop. The requirement of rules of industrial dispute in so far as the right of hearing of the delinquent is concerned cannot and does not extend to a delinquent to be represented through counsel or agent. Stop stanza.